Welcome to another episode on the Law Report. It has been a long time, and this is my first episode for 2026. And this episode was meant to be recorded since November 2025. And I do apologize for the quality of this video if it doesn't look good at all because I'm recording this on a very miniature camera with low resolution. But let's push on. Today's topic is: when can a judge conduct a trial without a jury in the Turks and Caicos Islands? A few months ago, there were media reports, and this is back in 2025. There were media reports of some sort of confusion as to when a judge can conduct a criminal trial without a jury, and this is commonly known as judge alone trial. We'll be back to discuss this matter shortly, but before we do, my usual disclaimer: nothing that I say in this episode is legal advice. You should not rely on it. For legal advice, please contact a competent lawyer of your choice. Welcome back. It was widely reported late last year, 2025, that a criminal trial in the Supreme Court in the Turks and Caicos Islands was recently aborted because the defense attorney raised issues with the way the jury pool was selected, arguing that it was contrary to the Jury Act. It appears that the court agreed with the defense attorney's arguments, but instead of granting the remedy the defense argued for, which was a stay of the proceedings, it was reported that the judge, in his wisdom, decided to order that the trial proceed by judge alone. This matter did not proceed eventually because an appeal was lodged by the defense. But before I look at the legislation and the requirements to be met before a criminal trial in the Turks and Caicos Islands can proceed by a judge alone trial, let me say this quite clearly, that contrary to popular beliefs, there is no constitutional right in the Turks and Caicos Islands to a jury trial or to be judged by your peers. I cannot find any such provision in the Constitution of the Turks and Caicos Islands, and reliance on common law in this instance would be futile. There is no statutory absolute right to trial by jury in criminal cases in the Turks and Caicos Islands. This right once existed but was removed by the Trial Without Jury Ordinance in 2010. This ordinance is now embedded in the Criminal Procedure Act of the Turks and Caicos Islands. However, in my view, a right to a jury trial still exists, but it is now a qualified right subject to certain statutory requirements being met. So, in the instant case, did the court fell into error in regard to the law? That is the question. that would be decided by a higher court, in this case, the Court of Appeal of the Turks and Caicos Islands. Did the court get it wrong in ordering a trial without jury in this specific case? This is ultimately what the Court of Appeal, as the final arbiter on this matter, will have to decide. As previously stated, the Criminal Procedure Act is the controlling or governing legislation in this area of the law. Section 58 of the Act deals with an application for a trial to be conducted without a jury, and it states, subsection 1 of section 58, that notwithstanding anything to the contrary in any other law, a judge may order that a trial be conducted without a jury if he is satisfied that the interests of justice so require. 2. An order under subsection 1 may be made on the application of any party to the trial or by the judge on his own volition. Subsection 3 states that in making a determination as to whether the interests, and this is very important, as to whether the interests of justice require that the trial be conducted without a jury, the judge shall have regard to all the prevailing circumstances of the case, including the following: A, the nature of the charges, the complexity of the issues or matter to be determined, and any steps which might reasonably be taken to reduce the complexity of the trial. C, the length of the trial, and any steps which might reasonably be taken to reduce the length of the trial. D, the likelihood that if a jury was selected, pre-trial publicity may influence its decision. E, any information tending to suggest that jury tampering may arise. So this section places a reasonable burden, a reasonable onus on the court to examine in detail all the circumstances of the case before coming to a decision whether or not a judge alone trial should proceed and whether it is in the interest of justice to do so. Now, what are the procedures for applications or an application for a judge alone trial? Well, let's look at section 59 of the Act. And it states that an application under section 58 shall be made to the court within 28 days after the committal of the defendant and serve on all other parties. 2. A party who wishes to oppose an application made under section 58 shall within 7 days of receiving a copy of the application and shall file with the court written representations, including a short explanation of the reasons for opposing such application, and shall serve copies thereof on all other parties. So, the legislation informs us that either party to the trial, that is the prosecutor or the defense attorney, can make an application for trial without jury, or the judge can do so of his own volition, but certain considerations must be had before any such decision is made. Now, I understand that in this specific case, the court indicated that its decision to order a judge alone child was based on the length of the child, but I'm told that the length of the child was slated for 5 days. In my view, I found nothing exceptional or extraordinary with that timeline. In fact, I would venture to say that 5 days in a criminal trial in the Turks and Caicos is very short, but more about that later in this episode. In my opinion, the legislature considered this issue of child without a jury to be a serious matter, so fundamental to the rule of law that it did something very unusual. Now, why do I say that? It is because normally there is no interlocutory appeal in criminal trials, but the legislature deemed this qualified right to be so important that by virtue of Section 6 of the Criminal Procedure Act, it provided for an immediate appeal of the decision of a court who decides to conduct a judge alone trial. And when I say interlocutory appeal, what I mean an appeal before the trial has concluded. What this means is that once the court has noticed of an appeal, any decision must be temporarily stayed, or the matter will not proceed until that point of law is determined by the Court of Appeal. Now let's look at Section 61 of the ordinance, which deals with appeals in this matter. Section 61, and we're looking at subsection 1, and it says that subject to subsection 2, an appeal shall lie to the Court of Appeal from an order under Section 58, and any determination by the Court of Appeal shall be final. So this simply means that whatever decision is made by the Court of Appeal, it is a final decision. You can't appeal to a higher court. You can't challenge the decision of the Court of Appeal. So there is finality. And it goes on to say that no appeal shall lie from an order under Section 58 except on a point of law. So it's not a factual argument. You're not arguing on the facts of the matter. You're arguing strictly on a point of law. Now, subsection 3 of Section 61 states that subject to subsection 2, notice of appeal by any party dissatisfied by the decision shall be filed and served on all other parties within 7 days of the determination by the court or by the judge, accompanied by the grounds of appeal and the point of law which the appellant wishes to raise, and the registrar, that is the registrar of the Court of Appeal, the Supreme Court, shall forthwith ensure that such appeal is listed for hearing within 60 days of the filing of the appeal. So yeah, this matter is so serious that there are very strict timelines to be observed. But let's look at what the Privy Council had to say on this issue. In the case of Michael Mizik et al., I found the following paragraph very instructive paragraph 53 in that case, where the court stated, and I quote, "It should be emphasized that the possibility of trial by judge alone, provided for by the Turks and Caicos trial without jury ordinance, is an exceptional departure from the normal mode of trials for serious offences before the Supreme Court of the Turks and Caicos Islands, which is by Section 3.1 of the Criminal Procedure Ordinance, trial by judge and jury, just as under the differently worded English and New Zealand legislation, departure must be justified. An order for trial by judge alone can be made only where the inches of justice require it, just as in England, it can be made only where it is necessary. So, it is not something that we done willy-nilly or by the whims and fancy of the court, or if the court is frustrated with how things are proceeding. No, the court must have good reasons. And that is why the Criminal Procedure Act at Section 58 set out exactly the steps that the court must go through to ensure that it is necessary to conduct a trial without a jury, even if it is only a qualified right in the Turks and Caicos Islands. Now, in this trial, this instant trial that I'm discussing, I am told, and it is or was widely reported, that the court cited the length of the trial as justification for its decision to order trial by judge alone. So, let's look at Section 58, subsection C of the Act, as it deals with the length of the trial as a consideration when determining whether to order a judge alone trial. Subsection C reads as follows: "The length of the trial and any steps which might reasonably be taken to reduce the length of the trial." The question then arises, what reasonable steps were taken by the court to reduce the length of the trial? I understand that none was taken, and off the top of my head, I can think of several steps. Absent any attempt to effect or to give effect to the subsection, which is subsection C, in my view, the court decision would not be justified, as I considered a 5-day trial in a criminal matter in the overall context of criminal trials in the Turks and Caicos Islands to be exceedingly short. There is also no indication that this was a complex trial. One of the considerations required by subsection B, and in any event, the court would have been required to take steps to require the complexity of the trial or the length of the trial before making any determination as to whether the trial should proceed by judge alone. Accordingly, in my view, the legislation as intended is for the court to carry out an assessment of the circumstances unique to the case before it before arriving at its decision. And this has to be carried out on a case-to-case basis, must be on a case-to-case basis. In my view, without a thorough analysis of the circumstances of the case and adherence or deference to Section 58 of the Criminal Procedure Act, any decision to conduct a trial without a jury or a judge alone trial would not be justified. Absent a thorough analysis in each individual case before the court, this would mean that effectively in one fell swoop, a court alone would not only have the power to suspend jury trials in the Turks and Caicos Islands, but effectively abolish it. This is something that only the legislature has the power to do. Here is where I'm going to leave this subject for now. I will continue to monitor it all the way to the Court of Appeal as I'm aware that the decision was appealed. If you like this video, please like, please share, please comment, and I will see you very shortly in another video. But most of all, I thank you for taking time out to look at this video. Cheers.